Hello guys, myself Saili, roll number 8, and my co-mates are Mustaba, roll number 11, Rashi, roll number 12, Sunit, roll number 23, and Babita, roll number 28.
Hello and good morning to one and all. So today we are going to talk to you about special types of customer. So firstly, what is special type of customer? By opening an account, the banker enters into a contractual relationship with the customer. Every person who is competent to contract can open an account with the bank. The capacity of certain classes of person to make valid agreement is subject to certain legal instructions. So the classes of people who has certain legal instructions while opening an account in the bank is called as special type of customer. So the first type is a married woman. A married woman can enter into a contract and bind her personal assets. Banks should observe extra precautions regarding sanction of overdraft or loan to a married woman because will have no remedy against her if she does not have any personal assets. Her husband will not be liable for any debt of his wife except in the following cases. First, where the loan is taken with his consent or where she acts as the agent of her husband. Second, where the loan has been taken for the purchase of necessities which the husband has failed to provide. So the second type is an illiterate. An illiterate person means a person who can't sign his name or even read or even write. While opening of an account of such a person is unavoidable, the bank should obtain first left thumb impression on the account opening form and specimen signature card in the presence of an authorized bank official. Second, details of identification marks should be noted on the account opening form and specimen signature card. Third, at least 2 copies of photography duly attested by any account holder or authorized bank official. Now my friend Sunit will talk to you about lunatics and drunkards.
Hello friends, today I am talking to you about lunatic and drunkard. Lunatic or lunatic is a person of unsound mind. He cannot form a rational judgment. Hence, he has no capacity to enter into a contract. Under Indian Contract Act 1872, a contract with lunatic is avoided. The reason being that the lunatic, being of unsound mind, is not competent to comprehend the meaning of a contract. If the banker, without knowing that the person is a lunatic, opens an account and enters into contract, acting in good faith, he is protected. But when once he gets a notice of lunacy of a person, he shall not enter into any contract. Drunkard. A drunkard is disqualified from entering into a contract when he is incapable of understanding the implications of the contract due to the effect of liquor. Under Section 12 of Indian Contract Act 1872, a man who is drunk cannot understand the contract or from rational judgment. He cannot enter into contract while such delirium or drunkenness. When a customer who is drunk presents a check across a counter, the payment must be witnessed. Now my friend Mustafa tell about minor, joint account holder and trustee.
Good morning, friends. Today I am going to talk to you about minor. Minor. A person under the age of 18 years is a minor. If a court appoints a guardian and the minor is below 18 years, then minority is extended up to 21 years. As per Section 11 of the Contract Act, a minor is not competent to contract, but Section 26 of the Negotiable Instrument Act allows a minor to draw, endorse, deliver, and negotiate negotiable instrument. See, a banker can open an account in a minor's name. This account will be safe if the account runs with credit balance. The minor can be partner, but he cannot be held liable for the liabilities of the partnership firm. A minor saving account may be opened in any of the following ways. First, in the joint name of the minor and his or guardian, the account will be operated jointly by the minor. Second, in the name of guardian, this account will be operated by the guardian on behalf of the minor. Now let's talk about joint account holders. A joint account holder is a bank or brokerage account shared by two or more individuals. Joint account holder have equal access to fund but also share equal responsibilities for any fees or charges incurred. Transaction conducted through a joint account may require the signature of all parties. Joint owner or co-owner means that both owners have the equal access to the account. As an owner of the account, both co-owners can deposit, withdraw or close the account. You most likely want to reserve this for someone with whom you already have a financial relationship, such as a family member. Now let's talk about trustee. A trustee is a person or firm that holds and administrates property or assets for the benefit of a third party. A trustee may be appointed for a wide variety of purposes, such as in the case of bankruptcy, for a charity, for a trust fund, or for certain types of retirement plans or pensions. Trustees are trusted to make decisions in the beneficiary's best interest and often have a fiduciary responsibility, meaning they act in the best interest of the trust beneficiaries to manage their assets. Now, my friend Babita will talk to you about administrators and executors.
Hello friend. Now I am going to talk about executor and administrator. Executor and administrator are allowed to open bank account. Following formalities are to be observed while opening the account of a deceased person. An executor should submit a probate and an administrator should submit the letter of administration to the bank as a proof of his authority to operate the account of a deceased person. The bank should thoroughly consider the probate letter of administrator to familiar himself with the power and function of executor or administrator. An account may be operated in the name of executor or administrator. The following style: ABC executor or administrator of the estate of decades. In case of joint executor, administrator, a mandate signed by all of them should be obtained regarding the operation of the account. The insolvency or lunacy of the executor or administrator will terminate his authority to operate the account unless it has been overdrawn. Thank you. Now my friend Rasi will tell you about PA account holder.
Hello friends, I am going to talk about power of attorney account holder. Power of attorney is all about giving the rights to act on your behalf to a trusted friend or family member. A power of attorney allows the holder of the POA to take clearly defined actions and decisions on behalf of the donor. In this case, the person who gives the power of attorney is known as the donor, while the person who gets the POA is called the holder. But there are some precautions you need to take while signing the POA agreement and ensure that your interests are fully protected. Let us look at it entirely from the point of view of the donor. Let us focus on things to know about power of attorney and power of attorney right and limitations. Above all, there are some basic rules you need to follow irrespective of whether you are given the power of attorney to a family member or to a trusted friend. To conclude our topic, we know that customers of banks consist of millions of private individuals, hundreds of thousands of small businesses, some formed as private limited companies, the majority being sole traders or partnerships. Some persons like minors, drunkards, lunatics, and insolvent not competent to enter into valid contracts. Thank you.
So, this brings us to the end of the presentation. We hope you like it and find it productive and useful. Thank you.